Before we begin, a quick and important disclaimer. The information presented in this video regarding 401k accounts, asset division, divorce proceedings, and related legal and financial concepts is intended strictly for educational and entertainment purposes only. I am not a licensed financial advisor, a certified public accountant, or a family law attorney. The division of retirement assets during a divorce is governed by complex federal and state laws that vary significantly depending on your jurisdiction. None of the historical trends, case studies, or academic theories discussed here should be construed as legal, financial, or tax advice. Every individual's financial situation is entirely unique, and the potential outcomes of a divorce settlement depend on a multitude of personal factors. Always conduct your own thorough due diligence and consult with qualified legal counsel and financial professionals before making any decisions regarding your retirement accounts or legal proceedings. Imagine waking up at 55, expecting a comfortable retirement, only to realize that a seemingly standard bureaucratic document, signed a decade earlier, legally stripped you of half your life savings, plus unexpected tax penalties that will bleed your remaining accounts dry. It happens every single day in the United States. In fact, a quiet financial catastrophe is actively destroying the retirement plans of millions of Americans. And the terrifying part is that the mechanism behind it isn't hidden in some shady offshore account. It is written in plain English, meticulously detailed, and legally validated within the pages of American academic textbooks on family law and financial planning. We are talking about the complete surgical dismantling of the American 401k during a divorce. You might think you know how asset splitting works. You might assume it is a simple 50-50 split, a clean break dictated by a judge in a courtroom. But what if I told you that the academic framework governing the division of defined contribution plans is riddled with historical complexities, mathematical nuances, and legal traps that can completely obliterate your financial future if you do not understand the underlying theory? Today, we are cracking open the actual academic literature that forensic accountants and legal scholars use to determine exactly who gets what when a marriage ends. What we are about to explore is not the superficial, generalized advice you hear on daytime television. We are going to deconstruct the exact textbook methodologies that dictate the fate of the largest single asset most Americans will ever own. For the vast majority of households in the United States, a 401k or similar defined contribution plan represents the culmination of decades of labor, sacrifice, and compound interest. Yet, when a marriage dissolves, this monumental asset is often treated with a shocking lack of technical understanding by the very people it belongs to. The problem this masterclass solves for you today is the dangerous knowledge gap between the everyday American worker and the specialized academic frameworks utilized by the legal and financial systems. By the end of this deep dive, you will understand the theoretical and practical mechanics of 401k division, not as a passive observer, but as a highly educated participant. You will see exactly how academic texts instruct professionals to value, isolate, and distribute tax-deferred growth. We will examine historical trends in family court rulings, explore complex case studies detailed in financial jurisprudence, and break down the precise step-by-step mechanisms that transfer wealth from one spouse to another. To truly grasp the magnitude of what is at stake, we must first understand how American academic literature defines the 401k in the context of a marital estate. In lay terms, you might view your retirement account simply as a bank vault with a fluctuating daily balance. But open any graduate-level textbook on property division, and you will see it defined quite differently. It is categorized as a highly volatile bundle of rights. This bundle comprises premarital principal, active marital contributions, passive market appreciation, unvested employer matches, and embedded future tax liabilities. When a divorce occurs, the court does not simply look at the bottom line number on your monthly statement and divide it by 2. Instead, the academic approach requires a forensic surgical unbundling of these specific rights. Consider the historical trend that led to this complex reality. Prior to the Employee Retirement Income Security Act of 1974, universally known as ERISA, the protection of retirement assets during divorce was a fragmented, chaotic landscape governed entirely by inconsistent state laws. ERISA was introduced by the federal government to protect employees' pensions from corporate mismanagement and aggressive creditors, implementing incredibly strict anti-alienation provisions. In simple terms, federal law stated that absolutely nobody could touch your retirement money. However, this sweeping legislation created a massive unintended consequence in the realm of family law. If a spouse was legally entitled to half of the marital assets under state law, but federal law strictly prevented the division of a pension or a 401k. Spouses, predominantly women at that specific time in history, were being left financially destitute after decades of marriage, despite the existence of massive retirement funds held by their partners. Academic scholars, economists, and legal theorists debated this legislative crisis for a full decade. The solution, which is heavily analyzed in legal textbooks today, finally arrived with the Retirement Equity Act of 1984. This act carved out a highly specific, mathematically rigorous exception to ERISA's ironclad anti-alienation rule. This exception is known as the Qualified Domestic Relations Order, or the QDRO. The QDRO is not just a standard legal form or a simple piece of paper. It is a deeply complex legal instrument that must perfectly bridge the gap between state-level family law, which grants the divorce itself, and federal tax law, which aggressively governs the mechanics of the 401k. The critical problem you face today, and the exact problem we are systematically solving right now, is that a flawed understanding of this intersection can trigger catastrophic, irreversible financial penalties. If one attempts to divide a 401k without strictly adhering to the theoretical models outlined in these academic and legal texts, they are effectively dealing with unexploded financial ordnance. A miscalculated withdrawal, a poorly drafted distribution sequence, or a failure to meticulously account for market timing between the official date of separation and the ultimate date of asset distribution can result in devastating outcomes. Potential outcomes of a botched division include mandatory 20% federal withholding taxes, an additional 10% early withdrawal penalty if the receiving party is under the age of 59 and a half, and the permanent, unrecoverable loss of decades of compound growth potential. Throughout this masterclass, we will dissect historical case studies where seemingly equitable splits on paper resulted in one party walking away with massively inflated after-tax wealth, while the other party unwittingly bore the brunt of hidden, deferred tax liabilities. We will deeply explore the academic debate surrounding the tracing of premarital funds, specifically focusing on how forensic accountants utilize the coverture fraction and other complex algorithmic models to isolate the exact dollar amount that legally belongs to the marriage versus the individual. You will learn the historical trends of how severe market volatility during the prolonged divorce process itself, a phenomenon heavily scrutinized in modern financial textbooks, can radically alter the actual purchasing power of the divided asset by the time the ink dries on the final decree. This is not about seeking loopholes. This is about achieving a granular, academic understanding of how the legal system categorizes, values, and ultimately redistributes your life's work. To begin this granular examination, we must immediately confront the most misunderstood concept in the entire field of family financial jurisprudence. This is the rigid legal boundary between separate property and marital property. In the context of a defined contribution plan, this boundary is never a static line. It is a constantly shifting mathematical frontier. Academic textbooks dedicate entire chapters to the methodology of tracing, which is the exhaustive forensic process of proving mathematically what exact dollar amounts existed before the marriage ever occurred. Imagine, if you will, a standard scenario taking place right now in the year 2026. Meet Robert, a 45-year-old software engineer living in the United States. Robert started contributing to his employer-sponsored retirement account at age 25. He married his spouse Jessica at age 35. After 10 years of marriage, they are now navigating the divorce process. The general public almost always assumes that because Robert held the account for 10 full years prior to the marriage, he is legally entitled to simply keep whatever the balance was on his wedding day. The assumption follows that only the financial growth occurring over the subsequent 10 years of marriage is subject to division. Extensive academic literature proves this common assumption is not only completely incorrect, but mathematically dangerous for the account holder. Financial textbooks define the growth of premarital assets in two highly distinct categories. These are passive appreciation and active appreciation. Passive appreciation refers exclusively to the market-driven growth of the specific funds Robert accumulated before he ever met Jessica. According to strict academic legal theory applied in many jurisdictions, this purely passive growth of premarital funds should technically remain Robert's separate property. However, identifying that exact numerical figure, a full decade later, is an exceptionally difficult forensic task. Financial professionals cannot simply look at a paper statement from 10 years ago and subtract that static number from the current balance. To do so would completely ignore the time value of money. Instead, they must meticulously account for 10 years of compound interest, complex stock splits, automatic dividend reinvestments, and the specific market fluctuations tethered to the exact mutual funds Robert held on the afternoon of his wedding. When the tracing of these specific shares becomes mathematically impossible, due to the commingling of funds or missing historical statements, the legal system routinely relies on a specific mathematical formula heavily detailed in financial jurisprudence. This formula is known as the coverture fraction. The coverture fraction is a specialized ratio utilized to arbitrarily slice the asset. The numerator of this fraction represents the total amount of time the employee spouse participated in the retirement plan during the exact time frame of the marriage. The denominator represents the total amount of time the employee spouse participated in the plan overall. In our scenario with Robert, he was contributing to the plan for 20 years total, and he was married for 10 of those years. The resulting fraction is 10 over 20, or exactly 50%. Under this academic model, 50% of the total current overall value of the entire portfolio is legally categorized as the marital portion, making it fully subject to division. The remaining 50% is categorized as Robert's separate property. But the academic analysis detailed in family law textbooks goes much deeper and becomes much more perilous than this basic division model. What happens when Robert changed his investment allocations during the marriage? Suppose Robert aggressively moved his premarital funds into high-risk technology stocks in the year 2024, resulting in massive portfolio gains. Did that active trading during the marriage legally convert the passive premarital growth into active marital growth? This is exactly where historical trends in appellate court rulings become critical to understand. In numerous legal jurisdictions, if a spouse actively manages a premarital asset during the time frame of the marriage, the resulting appreciation can be legally transformed into shared marital property, effectively stripping the original account holder of their separate property claim. Legal and financial textbooks refer to this mechanism as transmutation. Transmutation is essentially a legal alchemy that turns individual wealth into shared marital assets simply through the routine act of logging into an account and rebalancing a portfolio. To defend against transmutation, the burden of proof rests entirely on the individual claiming the separate property. Academic texts dedicate pages to explaining how this burden requires producing historical statements, trade confirmations, and plan documents spanning decades, documents that most Americans simply do not retain. Without this exhaustive paper trail, courts are instructed by established legal precedent to presume that commingled funds are entirely marital property. Furthermore, we must deeply examine the explosive concept of the valuation date. This is the exact calendar date the court strictly utilizes to determine the final legal value of the retirement portfolio. The public generally assumes the account is valued on the exact day the divorce is officially finalized by a judge. This is very often not the case. Depending entirely on the specific state jurisdiction, the valuation date could be the date of physical separation, the date the divorce petition was formally filed with the court, or the date of the actual trial itself. In the year 2026, dealing with unprecedented global market volatility, the time gap between the date of separation and the date of final distribution can easily stretch anywhere from 12 to 36 months. During this prolonged period of legal limbo, the account continues to generate passive gains or suffer passive losses. Who owns those gains or losses occurring between separation and finalization? The academic literature refers to this as the problem of post-separation market experience. If the court ignores this post-separation market experience, one party will inevitably receive an artificial windfall at the direct expense of the other. Consider a historical case study heavily cited in forensic accounting courses. A couple files for divorce when the portfolio balance is exactly $500,000. The court orders a 50-50 split based strictly on the date of filing, legally awarding $250,000 to the non-employee spouse. However, the complex legal process drags on for 2 full years. During those 2 years, a severe market downturn occurs, and the total value of the portfolio plummets to $300,000. Because the legal decree originally specified a flat dollar amount based on the historical valuation date, rather than a dynamic percentage of the current value, the non-employee spouse still legally extracts their $250,000. The original employee spouse who funded the account is left holding a devastating $50,000. This specific historical scenario perfectly illustrates why achieving a granular academic understanding of these mechanisms is absolutely paramount for anyone holding defined contribution assets. The portfolio is a living, breathing financial entity tethered to the volatile global markets. It does not pause its daily fluctuations simply because a marriage is ending. The failure of legal counsel to properly specify whether an asset award is a flat fixed dollar amount or a dynamic percentage of the account at the exact time of physical distribution is widely considered one of the most common and financially catastrophic errors detailed in legal malpractice literature. Understanding the mathematics of the coverture fraction and the profound financial impact of the legal valuation date is only the first foundational layer of the forensic accounting process. Once the exact marital portion is finally calculated and agreed upon by the court system, the actual physical division of the money must take place. This is exactly where the theoretical math meets the unforgiving reality of the Internal Revenue Service. It is at this precise moment that a single improperly phrased sentence, hidden within a court document, can trigger a mandatory and irreversible tax event that permanently vaporizes 20% of the transferred wealth before it ever reaches the receiving spouse. How does a seemingly routine legal transfer suddenly become a highly taxable early distribution? And what specific legal language do academic textbooks mandate to prevent the federal government from claiming a fifth of your life savings in the process? The answer lies in the terrifying mechanics of constructive receipt, a highly complex concept that dictates exactly when the Internal Revenue Service legally recognizes you as having physical or legal control over a financial asset. In the realm of academic tax law, you do not actually have to spend the money or even deposit the check into your local bank account to be taxed on it. The absolute second you possess the unrestricted legal right to draw upon those funds, the federal government classifies the transaction as a taxable distribution. This is the precise mechanism that traps thousands of divorcing Americans every single year. When a family court judge signs a finalized divorce decree awarding you a portion of your former spouse's retirement account, the execution of that transfer must be handled with surgical precision. If the legal paperwork simply demands that the account holder withdraw the funds and hand you a cashier check, or if the court order inadvertently instructs the financial institution to disburse the settlement directly to your personal name, you have instantly triggered constructive receipt. The potential outcomes of this administrative error are financially devastating. By federal law, any direct distribution from a qualified defined contribution plan to an individual is legally subject to a mandatory 20% federal withholding tax. The financial institution managing the account is required by statute to skim exactly 1/5 off the top and send it directly to the United States Treasury before the money ever leaves their corporate server. Imagine if we look at a highly common scenario unfolding right now in the year 2026. Meet Emily and David. David holds a massive corporate retirement account, and after a grueling legal battle, the court awards Emily exactly $200,000 of that specific asset as her legal share of the marital estate. Emily and her attorney, lacking a granular understanding of tax jurisprudence, submit a poorly drafted separation agreement that simply requests a standard payout. The corporate plan administrator complies exactly as instructed. They liquidate $200,000 from the market. However, because the instructions triggered constructive receipt, the administrator is legally forced to withhold $40,000 for the IRS. Emily opens her mail expecting a check for $200,000, but instead, she holds a check for $160,000. To prevent this immediate erosion of wealth, academic texts on financial planning outline a very specific mechanism known as a trustee-to-trustee transfer, also frequently referred to as a direct rollover. This requires incredibly precise legal language in the Qualified Domestic Relations Order, instructing the original plan administrator to move the funds directly into a newly established individual retirement account created specifically in the receiving spouse's name. When executed correctly, the funds move digitally from one financial institution to another without ever passing through the hands or the personal checking account of the individual. Because constructive receipt is completely bypassed, the 20% mandatory federal withholding tax is entirely legally avoided. The underlying asset remains fully tax-deferred, preserving the compound growth potential that is absolutely critical for long-term retirement survival. But what happens if the check is already cut? Financial textbooks detail a highly risky secondary mechanism known as the 60-day rollover rule. If Emily receives that check for $160,000, the federal government grants her exactly 60 calendar days to deposit those funds into a qualified IRA to retroactively shield them from permanent taxation. However, there is a massive mathematical trap hidden within this rule that bankrupts individuals routinely. To satisfy the IRS and completely avoid the tax penalty, Emily must deposit the entire original distribution amount. She must deposit $200,000 into the new IRA. Because the government kept $40,000 for taxes, Emily must magically produce $40,000 from her own completely separate personal savings to bridge the gap and make the account whole. If she cannot produce that cash within the strict 60-day window, the $40,000 withheld by the government is permanently classified as a taxable distribution, and she loses that wealth forever. The academic literature gets even more complex when we introduce the variable of age, specifically regarding the 10% early withdrawal penalty. Standard tax law dictates that if you withdraw funds from a qualified retirement account before the age of 59 and a half, you are penalized with a 10% fine on top of your ordinary income taxes. However, forensic accountants and specialized tax attorneys utilize a highly specific, heavily analyzed exception buried deep within the Internal Revenue Code. This is Section 72T2C. This incredibly powerful federal statute dictates that distributions made to an alternate payee pursuant to a qualified domestic relations order are strictly exempt from the 10% early withdrawal penalty, regardless of the receiving spouse's age. Let us examine the historical trends and practical application of this specific federal code. Suppose Emily is only 40 years old in the year 2026. She desperately needs $50,000 in actual liquid cash from her divorce settlement to purchase a new home for her children, and she plans to roll the remaining $150,000 into an IRA for her future. Because she is receiving this money through an official QDRO, she can legally instruct the corporate plan administrator to directly disburse $50,000 in cash to her bank account and transfer the rest to an IRA. She will absolutely have to pay ordinary income tax on that $50,000, but because of the Section 72T exception, she completely avoids the punitive $5,000 early withdrawal penalty. Yet, case studies in legal malpractice frequently highlight a catastrophic sequence of events regarding this exact rule. Many general practice attorneys, fundamentally misunderstanding the exact order of operations dictated by the tax code, will instruct their clients to first roll the entire $200,000 settlement into a brand new IRA, and then subsequently withdraw the $50,000 they need for a house down payment. This single, seemingly logical administrative step completely destroys the federal tax exemption. The Section 72T exception applies exclusively to funds distributed directly from the original corporate retirement plan pursuant to the QDRO. The absolute second those funds hit the new individual retirement account, the QDRO exemption vanishes permanently. When Emily withdraws the $50,000 from her new IRA the following week, the IRS correctly identifies it as a standard early withdrawal, and she is immediately slapped with a devastating, entirely preventable $5,000 penalty. Understanding the terrifying mechanics of constructive receipt, the mathematical traps of the 60-day rollover, and the strict sequential requirements of the early withdrawal exemption is the absolute baseline for surviving the division of a marital estate. But even if you master the academic tax theory, and even if your attorney drafts a mathematically flawless mathematical distribution model, you are still facing an enormous, entirely separate bureaucratic hurdle. Because here is the most shocking reality detailed in family law textbooks. The family court judge who presides over your divorce, the highest legal authority in your state courtroom, actually has zero legal power to force the corporate financial institution to execute the division of your funds. That absolute power rests solely in the hands of a completely unregulated, faceless corporate entity that operates under entirely different federal laws, and if they simply decide they do not like the specific font or formatting of your court order, they can freeze your entire life savings indefinitely. This terrifying reality is known in academic legal literature as federal preemption. While your local family court judge holds supreme authority over state domestic relations law, the corporate plan administrator operates strictly under the Employee Retirement Income Security Act, a federal statute that mathematically and legally supersedes state jurisdiction. Every single defined contribution plan in the United States is governed by a master plan document. This is not a simple marketing brochure or a human resources summary. It is a highly complex legally binding trust agreement that dictates exactly what can and cannot be done with the funds held within the corporate vault. Academic textbooks heavily emphasize that plan administrators have a strict fiduciary duty, exclusively to the plan itself and to federal law, not to the divorcing parties standing in a state courtroom. Therefore, if a state judge signs an order demanding a specific distribution method or an immediate cash payout that is not explicitly authorized within that specific corporate master plan document, the administrator is legally bound by federal law to reject the judge's order entirely. The state decree is effectively dead on arrival. Let us construct an imagine if scenario based on historical trends unfolding in the year 2026. Meet Sarah and Michael. Michael holds a substantial corporate retirement account with a massive multinational defense contractor. After a bitter 2-year divorce process, a state judge signs a domestic relations order legally awarding Sarah $500,000 from Michael's account. Sarah and her legal team mail the certified, judge-signed court order to the corporate headquarters, fully expecting a rapid and seamless transfer of wealth. 6 weeks later, they receive a formal rejection letter. The corporate legal department has officially denied the order. Why did a faceless corporate administrator deny a direct mandate from a state judge? Because Sarah's attorney drafted the order utilizing the generic corporate brand name of the employer, rather than the precise, legally registered alphanumeric name of the retirement trust fund, as filed with the Department of Labor. This single administrative oversight plunges Sarah into a bureaucratic nightmare known in legal circles as QDRO limbo. The legal document must now be completely redrafted from scratch, resubmitted to the opposing counsel for approval, re-argued before the family court judge to obtain a brand new signature, and finally resubmitted to the corporate plan administrator for a second review. This agonizing cycle easily consumes an additional 6 to 9 months. During this entire prolonged period, the $500,000 remains completely frozen in the market. The plan administrator places a strict administrative hold on the account. If the global economy experiences a severe market correction during this exact window in 2026, the potential outcomes are catastrophic. Sarah cannot move the funds to safer asset classes because she does not legally control them yet, and Michael cannot touch them or rebalance his portfolio because of the administrative hold. They are both trapped as passive observers while their net worth actively evaporates, all because of a missing word in a legal document. Furthermore, federal statutes actually grant corporate plan administrators up to 18 full months to determine the qualified status of a domestic relations order, giving them immense, unchecked chronological power over your financial timeline. But market volatility is not the most dangerous threat lurking during this administrative limbo. Academic textbooks on family law reserve their most severe warnings for the intersection of unapproved orders and the sudden death of the account holder. This introduces the highly complex legal concept of the qualified pre-retirement survivor annuity. Under federal law, the default beneficiary of any defined contribution plan is automatically the current legal spouse. When a divorce decree is finalized by a judge, the ex-spouse is immediately and automatically removed from that protected federal status. Consider a chilling historical case study, heavily analyzed in forensic accounting and law schools. A couple legally finalizes their divorce. The ex-wife is awarded a massive portion of the retirement portfolio. The domestic relations order is signed by the judge and mailed to the plan administrator. 3 days later, before the corporate legal team even opens the envelope to officially approve the order, the ex-husband dies in a sudden automobile accident. Because the corporate administrator had not yet legally qualified the order, the ex-wife held absolutely no recognized legal claim to the funds under federal law. Furthermore, because the state divorce was officially finalized days prior, she was no longer legally recognized as the surviving spouse. The entire financial settlement, representing decades of marital savings and sacrifice, completely bypassed her. The wealth was legally absorbed by the deceased husband's newly designated beneficiaries, or dumped directly into his estate. To prevent this exact catastrophic scenario, forensic legal texts mandate that a perfectly drafted asset division order must include incredibly precise survivorship language. It must legally designate the ex-spouse as the surviving spouse exclusively for the specific purpose of the divided asset, explicitly bridging the dangerous chronological gap between the state divorce decree and the federal corporate approval process. Failure to include this specific academic clause is widely considered a massive breach of fiduciary duty by legal counsel, yet it happens with alarming frequency because general practice attorneys often rely on outdated generic templates instead of meticulously tailoring the document to the specific corporate master plan. When an ex-spouse is caught in the survivorship trap, academic texts detail a desperate legal maneuver known as a nunc pro tunc order, which is Latin for now for then. It is an expensive attempt to get a state judge to backdate a corrected order to the original date of the divorce. However, federal appellate courts routinely strike these down, ruling that ERISA strictly prohibits retroactive alterations that violate the master plan document on the exact date of the account holder's death. This definitively proves the absolute supremacy of federal plan documents over state court intentions. We have now meticulously established the extreme mathematical volatility of separate property tracing, the devastating tax implications of constructive receipt, and the absolute sovereign power of the corporate plan administrator. But we have fundamentally ignored a massive financial illusion that plagues millions of American retirement accounts today. What happens when the bottom line number on your monthly statement is a complete and utter lie? What if the account balance you are fighting so fiercely to divide in court is artificially inflated by a massive hidden liability? Next, we must rip open the academic textbooks to examine the absolute mathematical chaos caused by outstanding 401k loans during a divorce. How does the legal system divide a phantom asset that is simultaneously a marital debt? And what happens when the employee spouse suddenly defaults on that loan exactly one day after the divorce is finalized? To unravel the profound complexity of this phantom asset, we must first examine how a corporate retirement loan is legally categorized under the United States Tax Code. When an individual takes out a loan against their defined contribution plan, they are not borrowing money from a commercial bank or a third-party lender. Academic financial textbooks clearly define this transaction as an internal liquidation of market assets. The plan administrator physically sells off a specific portion of the employee's mutual funds and transfers that cash to the employee. In exchange, a legally binding promissory note is placed back into the account. Herein lies the mathematical illusion that devastates countless divorce settlements every single year. When you look at a standard monthly statement, the corporate plan administrator will almost always report the total account balance by combining the remaining liquid market investments with the outstanding principal balance of the promissory note. The statement might display a total value of $200,000, but if there is a $50,000 outstanding loan, the actual investable, liquid cash sitting in the market is only $150,000. The remaining $50,000 is merely a ghost, a paper promise that the employee will eventually pay themselves back. Imagine if we analyze a common scenario occurring in family courts across the United States in the current year 2026. Meet Christopher and Amanda. They are dissolving a 15-year marriage. Christopher's retirement account statement proudly displays a bottom-line balance of exactly $300,000. Seeing this figure, the state judge signs a seemingly equitable order awarding Amanda 50% of the total marital asset, legally entitling her to $150,000. However, the judge, the attorneys, and Amanda all failed to properly analyze the granular footnotes of the corporate statement. 2 years prior, Christopher took out a maximum allowable $50,000 loan against his retirement account to fund a failing side business. The actual liquid capital inside the vault is only $250,000. When the corporate plan administrator receives the judge-signed domestic relations order, they strictly follow the mathematical instructions to transfer $150,000 to Amanda. Because federal law dictates that a corporate plan administrator cannot legally transfer a portion of a promissory debt note to a non-employee spouse, they must fund Amanda's entire award using only the available liquid cash. The administrator liquidates $150,000 from the market and transfers it to Amanda's newly established individual retirement account. The mathematical carnage for Christopher is instantaneous and catastrophic. Of his original $250,000 in liquid market assets, $150,000 is now gone. He is left with merely $100,000 invested in the market, while still carrying the absolute legal burden of the $50,000 promissory note. His actual net share of the liquid retirement wealth was reduced to a mere fraction of what he anticipated, completely destroying his long-term compound growth trajectory. This mathematical disproportion leads directly to the forensic accounting process of tracing the loan proceeds, a practice heavily detailed in advanced family law textbooks. To achieve a truly equitable distribution, forensic accountants must meticulously investigate exactly where the borrowed funds were spent. If Christopher used the $50,000 loan to remodel the marital kitchen or pay off joint credit card debt, academic theory dictates that the loan is a shared marital obligation. In this scenario, Amanda's settlement should have been mathematically offset to account for her half of the shared debt. However, if Christopher secretly used the $50,000 to pay off a separate premarital debt, or hid the funds in an undisclosed offshore account, the loan represents a unilateral depletion of the marital estate. Proving these historical trends in spending requires an exhausting, highly expensive forensic analysis of bank statements and wire transfers spanning multiple years. Without this rigorous academic tracing, one spouse will inevitably subsidize the hidden debts of the other. But the danger of the 401k loan multiplies exponentially when we introduce the threat of sudden default. What happens when the employee spouse suddenly defaults on that loan exactly one day after the divorce is finalized? Under the strict guidelines of the Internal Revenue Code, a retirement loan must be continuously repaid through automated payroll deductions. If Christopher is suddenly terminated by his employer, or if he intentionally resigns from his position in a calculated act of financial sabotage immediately following the divorce decree, the automated payroll deductions permanently cease. Federal tax law dictates that Christopher generally has until the due date of his federal tax return for that specific year to repay the entire $50,000 balance in one lump sum. If he fails to produce that massive amount of cash, the Internal Revenue Service executes a catastrophic mechanism known as a deemed distribution. The federal government legally categorizes the unpaid $50,000 loan as ordinary taxable income for that calendar year. Christopher is immediately hit with a massive income tax bill, and if he is under the age of 59 and a half, he is slapped with an additional 10% early withdrawal penalty. While this seems like Christopher's personal problem, historical trends in legal malpractice highlight a terrifying collateral consequence. If the divorce was finalized in November, and Christopher defaults on the loan in December of that exact same year, the couple may still be legally required or financially incentivized to file a joint federal tax return for their final year of marriage. The explosive tax liability generated by the deemed distribution is now attached to a joint tax return, making Amanda completely legally liable for a massive federal tax debt caused entirely by her ex-husband's post-divorce default. Academic textbooks emphasize that failing to include ironclad tax indemnification clauses in the final settlement, specifically designed to shield the non-employee spouse from deemed distribution liabilities, is a severe oversight that can bankrupt an innocent party years after the marriage has ended. We have now exposed the mathematical illusions of tracing, the federal traps of constructive receipt, the absolute supremacy of corporate plan administrators, and the hidden tax bombs of outstanding loans. But there is one final, terrifying variable that completely supersedes the power of the judge, the skill of your attorney, and the meticulous calculations of your forensic accountant. It is a completely invisible corporate event that can freeze your assets, block your court orders, and trap your life savings in a plunging global market with absolutely no legal recourse. What happens when the multinational corporation holding your retirement funds is suddenly acquired by a rival conglomerate precisely in the middle of your divorce trial, triggering a highly secretive, federally sanctioned financial blackout period, where not even a Supreme Court ruling can force them to release a single dollar of your money? This invisible corporate event is legally known as the Sarbanes-Oxley blackout period, a phenomenon meticulously documented in American business law textbooks, but rarely discussed in the public square. Under the Sarbanes-Oxley Act of 2002, whenever a major corporate event occurs, such as a change in plan administrators, a merger between two massive corporations, or a total restructuring of the investment menu within a 401k plan, the company is legally authorized to freeze all participant accounts. During this window, which can legally last up to 60 days or even longer under specific federal extensions, absolutely no transactions can be processed. You cannot trade shares, you cannot rebalance your portfolio, and most importantly for this masterclass, you cannot execute a qualified domestic relations order. Imagine, if you will, a scenario unfolding right now in early 2026. Meet Marcus and Elena. After 3 years of grueling litigation, they finally reach a settlement regarding Marcuse's $700,000 retirement account. The judge signs the order on a Tuesday. On Wednesday, Marcuse's employer, a major pharmaceutical firm, announces it has been acquired by a global healthcare conglomerate. On Thursday, Marcus receives an automated email stating that the retirement plan is entering a mandatory blackout period to facilitate the transition of assets to a new record keeper. For the next 8 weeks, those $700,000 are legally untouchable. If the stock market experiences a sudden sharp downturn during these 8 weeks, Marcus and Elena are forced to sit on the sidelines and watch their shared financial future evaporate in real time. They have zero legal recourse. A state court cannot override a federally mandated Sarbanes-Oxley blackout. The timing of corporate mergers is entirely beyond the control of the family court system, yet it can fundamentally alter the actual purchasing power of the divorce settlement before the first dollar is ever transferred. Academic literature on retirement plan administration highlights that these blackout periods are often the ultimate breaking point for high-stakes divorce negotiations. When the money is frozen, the leverage shifts. If one spouse is in desperate need of immediate liquidity to secure a new residence or pay mounting legal fees, a 2-month blackout can be used as a blunt force instrument in negotiations. Forensic accountants often point to historical trends where the mere threat of an upcoming blackout, mentioned in a corporate newsletter, forced a panicked spouse to accept a significantly lower settlement just to get the paperwork signed and processed before the freeze took effect. This is why deep-dive academic study of your employer's corporate filings is just as important as studying the divorce laws of your specific state. You are not just divorcing a spouse, you are navigating the bureaucratic machinery of a Fortune 500 entity. Beyond the structural freeze of a blackout, we must confront the academic reality of investment recapture and the lost opportunity cost. When a 401k is divided, the receiving spouse almost never receives a piece of every individual stock or bond held in the original account. Instead, the plan administrator typically liquidates a specific dollar amount or a specific number of shares to create a cash pile for the transfer. This leads to a massive, often ignored financial phenomenon known as being out of the market. Consider the mathematical implications for Elena in our 2026 scenario. Once the blackout ends and the administrator finally processes the QDRO, they sell $350,000 worth of mutual funds. This cash then sits in a non-interest-bearing clearing account for several days, or even weeks, while the paperwork is finalized and the check is mailed or the wire is initiated to Elena's new IRA. If the market rallies by 5% during those 10 days of administrative processing, Elena has permanently lost $17,500 in potential growth. Over a 20-year retirement horizon, that single week of being out of the market, compounded at a standard 7% annual return, represents a total loss of over $67,000 in future wealth. Academic textbooks on financial planning refer to this as frictional loss. In a standard divorce, these frictional losses are almost never accounted for in the settlement agreement, meaning the receiving spouse is starting their new independent financial life with a hidden deficit that they may never fully recover. The depth of this masterclass now requires us to look at the most sophisticated layer of academic tracing: the issue of unvested employer contributions. In the American workforce of 2026, many high-tier 401k plans utilize a vesting schedule, where the employer match only becomes the legal property of the employee after 3, 4, or 5 years of service. If a divorce occurs while a significant portion of the 401k balance is unvested, the legal system faces a theoretical paradox. Is an unvested contribution marital property if the labor that earned it happened during the marriage, even if the money could technically vanish if the employee is fired tomorrow? The historical trends in American case law have shifted toward a formulaic approach known as the deferred distribution method. Academic texts instruct judges that they cannot award an ex-spouse money that doesn't legally exist yet. However, they can award a contingent interest. This means the court order stays on file for years. Only when the employee finally hits their 5-year work anniversary and the funds vest does the administrator execute a second, delayed transfer to the ex-spouse. Imagine the administrative nightmare of tracking a former spouse's employment status and vesting schedule 5 years after you have stopped speaking to them. This creates a permanent, ghost-like tether between two people who are trying to move on, managed by a corporate human resources department that has no interest in your personal history. Furthermore, we must analyze the academic concept of the tax basis of the divided asset. Not all $401,000 are created equal. In the modern financial landscape, many participants hold both traditional pre-tax contributions and Roth after-tax contributions within the same 401k umbrella. A $300,000 balance comprised of $200,000 in traditional funds and $100,000 in Roth funds is a mathematical minefield. If the QDRO is drafted lazily and simply says divide the account 50-50, and the administrator takes the entire $150,000 settlement from the traditional pre-tax side, the receiving spouse has just inherited a massive future tax bill. Meanwhile, the employee spouse keeps the entire $100,000 Roth portion, which will grow and be withdrawn entirely tax-free. Academic textbooks on forensic accounting emphasize that a truly equitable division requires a pro rata distribution across all sub-accounts. This means the settlement must take a proportional slice of the pre-tax money, the after-tax money, and the employer match separately. Failure to specify a pro rata division in the legal paperwork is a subtle but devastating error that can result in one spouse effectively paying the other spouse's future taxes. It is the equivalent of trading a suitcase full of gold for a suitcase full of taxable income, and the most terrifying part is that the statement balance looks exactly the same on the day of the trade. We have now deconstructed the corporate blackout, the frictional losses of market timing, the administrative trap of unvested matches, and the hidden tax disparity between traditional and Roth sub-accounts. We are reaching the deepest levels of the masterclass, where the theory becomes even more counterintuitive. What happens when the 401k is not the only retirement asset, and the legal system attempts to perform an offset? What if, instead of dividing the 401k, the court gives one spouse the house and the other spouse the retirement account? On the surface, this looks like a clean break, but academic financial models prove that this is almost always a mathematical disaster for one of the parties. Why is a $500,000 house almost never equal to a $500,000 $401,000? And how do forensic accountants use the concept of tax-adjusted present value to prove that what looks like a fair trade is actually a slow-motion financial execution? This fundamental misunderstanding of asset parity is perhaps the most frequent point of failure in high-asset divorce negotiations. In the academic field of forensic economics, this is referred to as the apples to oranges fallacy. To the average person, and even to many overextended family law judges, $500,000 is simply $500,000. Whether that value is locked in the bricks and mortar of a family home, or sitting in a diversified 401k portfolio seems irrelevant. However, a deep dive into the academic theory of tax-adjusted present value reveals a startlingly different reality. Imagine if we analyze a typical scenario unfolding in the American suburbs in 2026. Meet Thomas and Linda. They are negotiating the division of their $1 million marital estate. Thomas wants to keep his $500,000 $401,000 because he values long-term growth and compound interest. Linda, wanting stability for their children, agrees to take the family home, which is also appraised at exactly $500,000 with the mortgage fully paid off. On the surface, this is a clean 50-50 split. But as any graduate-level financial textbook will explain, Linda has just unknowingly accepted a significantly more valuable asset, while Thomas has been handed a massive future tax bill. The home Linda received is a post-tax asset. Under current United States tax law, specifically the Section 121 exclusion, if Linda sells that primary residence in the future, she can potentially exclude up to $250,000 of gain from her capital gains taxes. The $500,000 she holds in equity is largely liquid and accessible without a massive federal penalty. Thomas, on the other hand, holds a pre-tax 401k. That $500,000 is not really $500,000. It is a gross figure. Every single dollar Thomas eventually withdraws from that account will be taxed as ordinary income at his future tax bracket, which in 2026 could easily range from 22 to 37% depending on his total earnings. If we apply a conservative combined federal and state tax rate of 25%, the actual spendable value of Thomas's retirement account is not $500,000, but rather $375,000. By choosing the retirement account over the house without demanding a tax adjustment, Thomas has effectively lost $125,000 of purchasing power on the very first day of his bachelorhood. To correct this, forensic accountants use a step-by-step methodology to reach what is called an equitable offset. First, they project the future tax liability based on the likely retirement age of the account holder. Second, they calculate the present value of those future taxes, discounting them back to today's dollars. Third, they adjust the distribution of other marital assets to compensate for the disparity. In the case of Thomas and Linda, an academically sound settlement would have required Thomas to receive a larger share of other marital assets, perhaps an additional $60,000 in cash or brokerage accounts, to bridge the gap created by the deferred tax liability of the 401k. Without this rigorous adjustment, the spouse keeping the 401k is essentially subsidizing the other spouse's tax-free lifestyle. But the complexity of offsets goes beyond just taxes. We must also consider the academic concept of liquidity versus utility. A house provides shelter, a utility that has an immediate and tangible value every single month. A 401k provides no immediate utility and is legally locked away until age 59 and a half. If Thomas needs cash for an emergency in 2027, he cannot simply sell a bedroom. He must take a taxable distribution from his 401k, potentially triggering that 10% early withdrawal penalty we discussed earlier. This lack of liquidity makes the 401k a less flexible and therefore less valuable asset in the immediate term, a factor that historical trends show is often ignored in standard mediation. Furthermore, academic texts on investment theory highlight the danger of the single asset concentration risk during an offset. When Linda takes the house and Thomas takes the 401k, they have both essentially placed their entire financial future into a single asset class. If the local real estate market in their specific United States city crashes in 2028, Linda's net worth plummets. If the stock market enters a secular bear market, Thomas is the one who suffers. By not dividing each asset 50-50, by not taking half the house and half the 401k, they have both abandoned the primary rule of financial survival, diversification. Academic scholars argue that while an offset is cleaner and reduces legal fees by avoiding a QDRO, it introduces a level of long-term risk that most divorcing couples are not emotionally or financially equipped to handle. This leads us to the even more obscure academic debate regarding the division of the 401k match and the concept of the marital effort. In many modern American corporations, the employer match is not just a gift. It is considered part of the employee's total compensation package, earned through their labor during the marriage. However, what happens when the employer match is subject to a cliff vesting schedule that has not yet been satisfied? Let's look at a case study involving a high-level executive at a tech firm in 2026. The executive has $300,000 in their 401k, but $100,000 of that consists of employer contributions that will not legally vest for another 18 months. Legal textbooks are deeply divided on how to treat this unvested $100,000. One school of thought, the subtraction method, argues that since the money isn't legally the employee's property yet, it cannot be marital property. The second, more modern school of thought, known as the marital foundation theory, argues that the marriage provided the emotional and domestic support that allowed the employee to stay at the job long enough to earn those unvested credits. Therefore, the non-employee spouse should be entitled to a portion of that money once it eventually vests. This requires the court to issue a dynamic order that remains open for years, a process that is administratively exhausting and prone to error. If the employee spouse is fired or quits before the 18 months are up, the asset vanishes for both parties. This introduces a moral hazard where an embittered employee spouse might intentionally leave their job just to ensure their ex-spouse never sees a dime of that unvested match, an act of financial spite that is notoriously difficult to prove in court. Even if you successfully navigate the tax-adjusted offsets and the vesting schedules, you still face the academic problem of the plan's underlying fees. Not all 401k plans are created equal. Some corporate plans are loaded with high internal expense ratios, administrative fees, and expensive managed volatility funds that quietly bleed the account of 1 to 2% of its value every single year. Academic literature on fiduciary duty suggests that if one spouse is forced to take half of a high-fee 401k, while the other spouse keeps a low-fee brokerage account, the split is inherently unequal. Over 20 years, a 1% difference in fees can result in a six-figure difference in final retirement wealth. Yet, how many divorce decrees specify that the 401k must be moved to a lower-cost provider immediately upon distribution? Almost none. We have now dismantled the illusion of the equal offset, the trap of the unvested match, and the silent erosion of account fees. We have reached the point in our deep dive where we must look at the most controversial and academically debated topic in the entire world of 401k divorce. It is the concept of the double dip. This occurs when the legal system treats the same 401k account as both an asset to be divided today and a source of income for alimony or child support tomorrow. Is it legally and ethically possible for the court to count the same dollar twice? And how do academic theorists justify a system that seems to mathematically punish the account holder for their own successful saving habits? The answer involves a complex intersection of property law and support statutes that can turn a standard retirement plan into a permanent, lifelong financial anchor. The academic concept of the double dip is one of the most intellectually polarizing and financially consequential debates in American family law today. In formal legal scholarship, it is often referred to as the double counting dilemma. To understand this, we must look at how state laws traditionally separate the concepts of property division and spousal support. Historically, the division of assets like a 401k was viewed as a one-time event intended to split the accumulated marital wealth. Alimony, on the other hand, was intended to be paid from future income. However, for a retiree or an employee nearing retirement in 2026, their primary source of future income is the very asset that was just divided in the divorce. Imagine if we analyze a scenario involving a long-term marriage ending in the year 2026. Meet Stephen, a 62-year-old executive who has spent 30 years building a $2,401,000. During the divorce, the court applies the standard academic models of property division and awards his spouse, Karen, exactly $1 million through a qualified domestic relations order. Stephen is left with the remaining million, However, because Stephen is at retirement age, the court also calculates alimony. To determine the amount Stephen can afford to pay, the judge looks at the monthly distribution Stephen is taking from his remaining $1,401,000. In this specific case study, the court has effectively counted the same $1 million twice. First, the court treated it as property to be divided with Karen. Second, it treated the remainder as a stream of income to be shared again with Karen through monthly support payments. Academic theorists who oppose double-dipping argue that this is a mathematical violation of equity. They contend that once an asset is divided as property, the portion remaining with the employee should be considered their separate, post-divorce property, and any income generated by that property should be exempt from support calculations. If the court ignores this, Stephen is essentially paying alimony out of his principal, which systematically exhausts his remaining wealth at twice the anticipated rate. Conversely, scholars who support the practice argue from the perspective of need. They maintain that the primary goal of the family court is to ensure that both parties can maintain a standard of living close to what they enjoyed during the marriage. If the retirement account is the only source of funds to provide that support, the court must be allowed to tap into it, regardless of whether it was previously divided as property. Historical trends in state legislation show a chaotic and inconsistent response to this dilemma. Some states, like Florida and New Jersey, have developed specific statutes or case law precedents that strictly prohibit double counting. In these jurisdictions, academic texts instruct attorneys to utilize a methodology known as the liquidation value adjustment. This requires a forensic accountant to calculate exactly what portion of the monthly distribution is coming from the principal that was already divided, and what portion is coming from new market growth that occurred after the divorce. Only the new growth is allowed to be counted toward income for support purposes. However, in many other states, the double dip remains a common potential outcome, leaving the account holder in a state of permanent financial vulnerability. This leads us to a deeper academic exploration of the Qualified Domestic Relations Order as a collection tool. While we have focused on using the QDRO to divide marital property, academic legal textbooks detail a secondary, far more aggressive use for this federal instrument, the QDRO for support. Under federal ERISA law, a retirement account is generally shielded from creditors. No bank, credit card company, or hospital can force a corporate plan administrator to hand over your 401k to pay a debt. However, the United States Congress carved out a singular powerful exception for family support. Consider an imagine-if scenario in 2026 involving a character named Richard. Richard has been ordered to pay $5,000 a month in alimony, but he has stopped making payments and has moved his liquid assets into offshore accounts or untraceable investments. However, Richard still has a significant 401k from a previous employer. In this situation, academic legal theory allows the recipient spouse to obtain a special kind of QDRO. This order does not divide the account as property. Instead, it instructs the plan administrator to make monthly distributions directly from Richard's 401k to his ex-spouse to satisfy the ongoing alimony obligation. This federal bypass effectively turns a private retirement account into a guaranteed government-sanctioned garnishable asset. The administrative costs and the tax implications of these recurring monthly QDRO payments are massive, often involving complex withholding requirements that leave the account holder with pennies on the dollar after the support obligation and the IRS are both satisfied. Furthermore, we must examine the academic concept of the survivor benefit in the context of the double dip. If Karen is receiving alimony from Stephen's 401k distributions, what happens if Stephen dies? Most alimony obligations terminate upon the death of the payer. However, as we discussed in earlier parts of this masterclass, if the original QDRO was not meticulously drafted to include specific survivorship language, the income stream for Karen would instantly vanish. This is why academic texts on financial planning for divorce emphasize the use of life insurance as a hedge against the loss of a 401k supported alimony stream. But in 2026, for a 62-year-old like Stephen, the cost of a life insurance policy sufficient to cover $1 million alimony obligation can be prohibitively expensive, leading back to a circular negotiation where the 401k itself must be further depleted to pay the insurance premiums. This intersection of property, support, and survivorship creates a phenomenon known in the academic literature as the divorce trap. This is a state of perpetual litigation where neither party can truly achieve financial independence because their primary assets are permanently entangled in a web of ongoing court orders and corporate administrative requirements. Forensic accountants point to case studies where the total legal and administrative fees spent over a decade of fighting over 401k distributions eventually exceeded the original value of the account itself. The only way to avoid this trap, according to the most recent academic frameworks, is to strive for a total buyout or a clean break settlement, even if it requires a significant short-term sacrifice of other assets. But a buyout introduces its own set of academic hurdles. How do you value a future stream of income in today's dollars when inflation in 2026 is an unpredictable variable? If Stephen offers Karen a lump sum of $500,000 today to waive all future claims to his 401k and alimony, how does he calculate the present value of a dollar that might be worth only 50 cents by the time he reaches age 80? This requires the use of the Monte Carlo simulation, a complex mathematical model utilized by financial theorists to project thousands of different market and inflation scenarios. Academic textbooks on divorce valuation now mandate the use of these simulations to prove that a settlement is fair, moving the legal process away from simple arithmetic and into the realm of advanced probability and data science. We have now pulled back the curtain on the double-counting dilemma, the aggressive use of support QDROs, and the mathematical complexity of the long-term divorce trap. We have reached the final foundations of our deep dive. But there is one final area where the academic literature and the reality of the American legal system collide in a way that most people are completely unprepared for. What happens when the 401k division is finally complete, the taxes are paid, and the accounts are split, but the United States government decides to change the rules of the game entirely? We must look at the impact of the Secure Act and subsequent federal legislation on the post-divorce 401k. How does a change in the required minimum distribution age, or the elimination of the stretch IRA fundamentally destroy the carefully calculated settlement you signed years ago? And is there any way to future-proof your retirement against a changing legislative landscape? The intersection of legislative volatility and marital dissolution represents the most unpredictable frontier in retirement planning today. When we open the pages of modern American financial textbooks, they are no longer static descriptions of law, but rather evolving manuals on how to survive the legislative shockwaves sent through the retirement system by the United States Congress. The primary catalyst for this instability is the Setting Every Community Up for Retirement Enhancement Act, or the Secure Act, and its subsequent iteration Secure 2.0. To understand the depth of this problem, we must analyze the concept of legislative obsolescence in the context of a signed divorce decree. Imagine if we examine a scenario from just a few years ago that is coming to a head in 2026. Meet Robert and Cynthia. In 2019, they finalized their divorce after 30 years of marriage. As part of their settlement, Robert was awarded the entirety of the 401k assets, while Cynthia was designated as the primary beneficiary of a specific $1 million inherited IRA, with the legal understanding that she could stretch the withdrawals over her entire lifetime. This strategy, heavily promoted in academic literature at the time, allowed the assets to remain tax-deferred for decades, providing a steady stream of income well into her 80s. However, the ink was barely dry on their settlement when Congress passed the Secure Act, which effectively eliminated the stretch provision for most non-spouse beneficiaries. Suddenly, the academic model Cynthia relied upon was illegal. Instead of stretching the tax liability over 30 years, she was legally forced to withdraw the entire $1 million within 10 years, triggering a massive, accelerated tax bill that wiped out 40% of the asset's value in a single decade. This historical trend of legislative interference proves that a divorce settlement is not a permanent shield. It is a contract written on shifting sand. In the academic study of post-divorce financial management, this is known as the regulatory risk premium. When a judge signs a decree in 2026, they are doing so based on the current tax brackets, the current required minimum distribution, or RMD, age, and the current definitions of qualified assets. But academic textbooks now emphasize that 401k holders must account for the high probability that the United States government will increase the RMD age again, or worse, modify the tax treatment of Roth conversions to capture more immediate revenue. Consider the step-by-step impact of the shifting RMD age. Under Secure 2.0, the age at which an individual must begin taking mandatory, taxable distributions from their 401k has been pushed back incrementally to age 75. While this seems like a benefit because it allows for longer tax-deferred growth, it creates a massive calculation error for divorcing couples who utilized an alimony formula based on the expectation that the account holder would begin withdrawing funds at age 72. In our current year 2026, many retirees are finding that their planned income streams are legally delayed, while their alimony obligations, often tied to a specific calendar date rather than the start of RMDs, remain due. This creates a liquidity crunch where the account holder is forced to take voluntary, potentially suboptimal distributions just to satisfy a court order, even if the academic ideal would be to leave the money invested. Furthermore, we must address the academic controversy surrounding the death of the stretch IRA in the context of a QDRO. Before these legislative changes, an ex-spouse who received funds via a QDRO could roll those funds into their own IRA and treat them as their own, effectively maintaining the most favorable tax treatment possible. But academic legal scholars are now debating whether future legislation could reclassify ex-spouses not as surviving spouses, but as non-spouse beneficiaries for tax purposes. If this shift occurs, the 10-year rule for total liquidation could be applied to millions of divorce settlements retroactively, forcing a massive nationwide sell-off of retirement assets that would flood the United States Treasury with tax revenue while bankrupting the very people the 401k system was designed to protect. This leads to the academic concept of the future-proofing clause. High-level forensic accountants are now instructing attorneys to include contingency language in 401k division orders that specifically address legislative changes. These clauses act as a legal reset button. For example, a future-proof decree might state that if federal law changes the taxability of 401k distributions by more than 5%, either party has the right to return to court to rebalance the marital estate. Without these clauses, the person who holds the 401k is taking on a disproportionate amount of legislative risk compared to the person who holds a post-tax asset like a house or a brokerage account. But there is a darker, more technical layer to this legislative reality that involves the concept of the inadvertent plan disqualification. Every 401k plan must maintain its qualified status with the IRS to remain tax-exempt. If a company's human resources department, overwhelmed by the complexities of new federal regulations in 2026, makes a systemic error in how they process QDROs or how they calculate employer matches, the entire plan can be disqualified. In this catastrophic scenario, every single dollar in the 401k, for every employee, becomes immediately taxable as income. Academic textbooks on ERISA litigation point to historical trends where small, administrative errors during a corporate merger led to mass disqualification. For a divorcing spouse who just received a $500,000 transfer, a planned disqualification at the corporate level would mean they are hit with a $200,000 tax bill for an error they didn't commit in an account they barely understand. To mitigate this, academic theory suggests a strategy of immediate diversification. The goal is to move the funds out of the corporate 401k environment and into a self-directed individual retirement account as quickly as the law allows. This moves the assets from the high-risk environment of corporate ERISA law into the relatively more stable environment of individual tax law. However, even this move is fraught with academic peril. If the transfer is not executed as a direct trustee-to-trustee rollover, the receiving spouse falls back into the trap of constructive receipt that we analyzed in the early stages of this masterclass. We have now explored the absolute highest levels of 401k divorce theory. We have deconstructed the forensic math of tracing, the federal supremacy of plan administrators, the hidden liabilities of loans, the illusion of equal offsets, the double counting of support, and the systemic risk of legislative changes. You have been through a deep dive that less than 1% of the American public will ever experience. But there is one final, overarching question that academic textbooks only answer in their closing chapters. What is the psychological and behavioral cost of all this complexity? Why do even the most intelligent people fail to execute these strategies? And what is the single biggest behavioral trap that leads to 401k total loss in the final moments of a divorce? In the final part of this masterclass, we will examine the theory of cognitive exhaustion in financial litigation and provide the ultimate step-by-step checklist for closing out a 401k division without leaving a single dollar on the table or a single tax bomb in your future. The theory of cognitive exhaustion is perhaps the most dangerous invisible variable in the entire landscape of American family law. In academic behavioral economics, this is often described as decision fatigue, a physiological state where the quality of decisions made by an individual deteriorates after a long period of intense mental strain. In the context of a 401k division that has dragged on into the year 2026, cognitive exhaustion is what causes otherwise brilliant professionals to surrender in the final hour, signing away hundreds of thousands of dollars in future value just to achieve a sense of psychological closure. Imagine if we look at the final case study of this masterclass. Meet Jennifer, a high-level marketing executive who has been locked in a divorce battle for 18 months. She has endured depositions, forensic audits, and 3 failed mediations. By the time the final settlement conference arrives, Jennifer is experiencing acute cognitive exhaustion. When her ex-spouse's attorney offers a settlement that appears roughly fair on the surface but contains a poorly drafted QDRO provision that ignores the market experience between the date of filing and the date of distribution, Jennifer simply signs it. She tells herself that the details don't matter as much as her freedom. Academic literature on litigation outcomes shows that this exact moment is when the most significant wealth transfers occur. The exhausted party effectively pays a massive, uncalculated peace of mind tax to the more resilient party. To counteract this, the academic framework for closing a 401k division relies on a rigorous, step-by-step technical checklist that must be followed with robotic precision, regardless of emotional fatigue. The first step in this closing sequence is the absolute verification of the qualified status of the order before the divorce is finalized. Historically, many attorneys would have a judge sign a domestic relations order and only then send it to the corporate plan administrator. This is an academic failure. In 2026, the gold standard is to submit the draft order for a formal pre-approval review by the plan's corporate legal department. This prevents the QDRO limbo we discussed in Part 4 and ensures that the very second the judge signs the decree, the corporate entity is already contractually obligated to honor the specific terms of the transfer. The second step is the implementation of the market experience clause. This is a technical provision that specifies whether the receiving spouse's share will be adjusted for investment gains and losses from the valuation date until the date of actual distribution. Without this clause, if the market rises 15% while the paperwork is being processed, the employee spouse keeps the entire windfall. If the market crashes, the receiving spouse might receive a share that is significantly larger than what was intended, effectively bankrupting the employee spouse's remaining account. Academic textbooks on actuarial science emphasize that failing to account for market experience is the single most common reason for post-divorce litigation, as one party always feels they were mathematically cheated by the timing of the market. The third step in the closing checklist is the mandatory tax basis audit. As we analyzed earlier, not all $401,000 are equal. Before the transfer is executed, you must obtain a written confirmation from the plan administrator detailing the exact proportion of pre-tax and after-tax funds being moved. If the transfer consists entirely of pre-tax dollars while the employee spouse keeps the Roth portion, the settlement is not actually 50-50. In 2026, with the high probability of shifting tax brackets, forensic accountants recommend adjusting the total dollar amount of the transfer to account for this future tax disparity. This ensures that both parties walk away with an equal amount of after-tax, spendable wealth, which is the only metric that truly matters in a retirement context. The fourth step is the verification of survivor benefits. As our masterclass has repeatedly emphasized, the death of an account holder during the administrative processing phase can be a total financial kill switch. The final closing documents must include specific language that designates the ex-spouse as the surviving spouse for the limited purpose of the 401k, until the very moment the funds are physically moved into the new IRA. This creates a bridge of protection across the most dangerous chronological gap in the entire legal process. The fifth and final step is the confirmation of the trustee-to-trustee transfer. The receiving spouse must provide the plan administrator with the exact alphanumeric routing details of their new IRA. This is not a task that should be left to a paralegal or an automated system. In 2026, cyber fraud targeting retirement transfers is at an all-time high. A single transposed digit in an account number can result in funds being sent into a digital void. Or worse, triggered as a direct distribution that incurs the 20% mandatory withholding tax we analyzed in Part 3. Academic textbooks on financial security now suggest a small test transfer of a nominal amount, such as $100, to verify the pathway before the full 6- or 7-figure settlement is moved. Beyond the checklist, we must confront the final academic reality of post-divorce life: the psychological re-anchoring of your financial identity. For decades, you may have viewed your 401k as a shared safety net. Now it is a solo vessel. Behavioral finance scholars point out that after a divorce, many individuals either become hyper-conservative, moving their entire 401k into low-yield money market funds out of fear, or they become hyper-aggressive, attempting to make up for lost time with high-risk investments. Both of these are outcomes that ignore the historical trends of long-term market growth. The academic goal is to return to a diversified, age-appropriate allocation that acknowledges your new, independent risk capacity. As we reach the conclusion of this 10-part deep dive masterclass, it is important to reflect on the historical trends that have shaped this landscape. From the introduction of ERISA in 1974 to the complex legislative maneuvers of the Secure Acts in the 2020s, the American 401k has been transformed from a simple savings vehicle into a highly complex, federally regulated battlefield. The academic textbooks we have explored today are not just for scholars. They are the survival guides for anyone navigating the dissolution of a marital estate. By understanding the mathematics of tracing, the supremacy of federal law, the hidden traps of loans and taxes, and the mechanics of corporate blackouts, you have equipped yourself with a level of knowledge that transcends the superficial advice found in common financial media. Potential outcomes for those who master these academic concepts are significantly more stable than for those who remain in the dark. While no one can promise a perfect result in a system as volatile as the American legal and financial sectors, the application of forensic logic and technical precision is the only way to safeguard the fruits of your decades of labor. You now understand that a 401k in a divorce is not a static prize to be won. It is a complex bundle of rights and liabilities that must be surgically unbundled. This concludes our deep dive into the academic reality of 401k divorce in the United States. You have the theoretical foundation and the practical checklist. You understand the variables and the risks. The question now is not what the law says, but how you will apply this specialized knowledge to protect your future. In our next series, we will take this forensic approach even further, moving beyond the 401k to analyze the even more obscure and heavily guarded world of executive compensation packages and non-qualified deferred compensation plans in high-stakes divorce. We will examine how golden parachutes and restricted stock units are valued when the marriage ends, and why the standard academic formulas for the 401k often fail when applied to the boardroom. The deep dive into the architecture of American wealth continues.